Today, we're diving into a landmark case that established a democratic principle that so many of us now just take for granted. This is the story of Tañada versus Tuvera, and it's all about one fundamental thing: your right to know the laws that govern you. So let's just kick things off with a simple question. Imagine this. You get in trouble for breaking a law you've never heard of, never seen, never had any chance to read because it was a secret. How is that fair? Can you really be punished for a rule you couldn't possibly know existed? Well, that exact question is what kicked this whole thing off.
And believe me, this wasn't just some theoretical what-if scenario. Things had gotten pretty chaotic. As Justice Fernand pointed out, it got so bad you'd see two totally different laws with the exact same number, for real. Presidential Decree 1686, for instance, was used once to grant citizenship, and then the same number was used again for a new tax on cars. That's the kind of confusion you get when laws operate in the shadows.
Right. So this brings us to the heart of the problem, which was really prevalent during the Marcos regime. The government was creating these things called presidential decrees, which were essentially laws. The catch? They weren't always publishing them. People were just expected to follow rules that were kept completely hidden from public view. Now, this practice goes against a massive constitutional principle: due process. You know, a huge part of due process is just basic fairness, which includes notice. You have to be able to know what the law is before you can be expected to follow it. So the very idea of a secret law that can get you in trouble, it's a complete violation of that right. So how on earth did the government justify this? Well, their entire argument relied on a loophole. They claimed that if a decree had the magic words effective immediately, well, that just meant you could skip publishing it altogether. And just like that, they created a backdoor to pass all sorts of secret laws. But a group of very determined citizens decided that was not okay. Led by the legendary statesmen Lorenzo Tañada, Abraham Sarmiento, and lawyers from the Mabini Group, a famous human rights organization, they did something about it. They took the government all the way to the Supreme Court. And the whole case really boiled down to a fight over a few words in the law. The petitioners, they were arguing that all laws, no exceptions, have to be published to be real laws. But the government kept pointing to that phrase, "unless it is otherwise provided," claiming it was their get-out-of-jail-free card to skip publication whenever they wanted. And the petitioners were incredibly smart about this. They didn't just ask the court for a simple win. They went further. They laid out these 5 key questions, basically asking the court to spell everything out, to define the rules so clearly that no one could ever use that loophole again. So this all leads up to the big moment, the climax of the story, where the Supreme Court steps in and delivers a final word that would completely change the game and redefine what it means to make a law in the first place. Okay, so here it is, Article 2 of the Civil Code. And look, you can see the exact phrase that caused all the trouble: unless it is otherwise provided. The whole case, all the arguments, it all came down to figuring out what those 5 little words really meant. And this is the aha moment. It's just a brilliant piece of legal interpretation. The court said, "You've got it all wrong. That phrase, unless it is otherwise provided, it doesn't mean you can skip publication. It means you can change the date the law takes effect. It can be sooner or later than 15 days, but, and this is the crucial part, only after it's been published. The publication itself is non-negotiable." The court couldn't have been more forceful. They used the word indispensable. Not important, not recommended, indispensable. It's an absolute requirement. What that means is that if a law isn't published, it's not a law. It has no power, no effect. It might as well be a blank piece of paper. And the court didn't just stop there. To make sure there was zero confusion ever again, they answered all of the petitioners' questions. They basically created a clear, simple rulebook for what transparency actually looks like in practice. First thing they did was define laws in the broadest possible way. It means everything. A city charter for just one town? Publish it. A private law that only grants citizenship to a single person? Publish it. Why? Because every single law, no matter how small or specific its target, is a matter of public interest and concern. This right here is a perfect cheat sheet. The rule of thumb is pretty simple.
If it's a rule that affects the public's rights and responsibilities, like a new tax, a city charter, or a central bank rule that changes how you bank, it has to be published. But if it's purely an internal thing, like a memo about the office dress code or instructions for staff, that doesn't need to be published. It's all about who the rule impacts.
And they also lay down strict standards for what counts as publication. You can't just publish the title or a summary. Nope, the entire law has to be published word for word. At the time, it had to be in the official gazette, and you had to do it fast. No more delaying or hiding laws in a drawer somewhere. So let's zoom out. What's the real legacy of this fight? I mean, this wasn't just a legal win. It was a monumental victory for transparency and for democracy itself. And it's a victory that still protects every single one of us today. I mean, listen to that. That's a direct quote from the decision. The days of the secret laws and the unpublished decrees are over. With one sentence, the Supreme Court drew a line in the sand. It was a complete and total shutdown of government secrecy in lawmaking. And the language they used, it's almost poetic, right? They created this powerful image. You can have laws that live out in the open, in the clear light of the sun, or you can have them skulking in the shadows. They made it very clear which side justice was on.
And this might be the best analogy in the whole decision. A furtive law, a secret law, is like a sword that's still in its sheath. It's useless. It's dangerous. For a law to actually work, to guide us, to protect us, to be legitimate, it has to be drawn from its scabbard, laid bare by publication for everyone to see.
So in the end, Tañada versus Tuvera did something amazing. It took this abstract idea of a right to information and made it real, concrete, and enforceable. It ensures that we, the people, can actually see and understand the rules that are being made in our name. Which brings us to a final powerful thought. The core truth of this case is simple. A law you cannot know is not really a law at all. That battle was won decades ago, but the principle behind it is something we always have to be vigilant about. It really makes you think. In today's world, how do we make sure we continue to protect and even expand this fundamental right to know?